My name's Peter MacDonald Eggers. I'm a barrister who specialises in commercial law, in particular international commercial law, which focuses particularly on insurance law, shipping law and international trade law. Today I'm going to provide you with an overview of Section A of the course on marine insurance law. Now, Section A is focused on the insurance contract itself. Now, before I discuss with you what the topics within the course of Section A are, I just wanted to explain to you how the chapters in each of the in this section are actually set out. Now, each chapter begins with a list of reference material, initially references in important textbooks and other academic literature, as well as references to the cases which are relevant to this area. And the more important cases are marked with an asterisk. Now, thereafter, there is a discussion of the relevant legal principles and doctrines which can be extracted both from the academic commentary but also, and more importantly, the cases. Thereafter, there is a summary identifying what you should have learnt from the chapter, and in order to test your understanding, there are a number of activities and some feedback provided. So, Section A is concerned with the contract of marine insurance itself. Within that section, there are four principal topics. The first is identifying the meaning and essential ingredients of a contract of marine insurance. Secondly, the doctrine of insurable interest. Thirdly, ways of classifying various types of marine insurance contracts. And finally, the principles associated with the assignment of a contract of marine insurance. Now, looking at the first topic first, the contract of marine insurance itself. Now, it's obviously important when you're dealing with any legal concept, but no less the concept of a marine insurance contract, to be able to identify what it is and to define what it means. And it's important for a number of reasons, because it helps one to identify and distinguish between a contract of marine insurance on the one hand, but a contract of non-marine insurance on the other hand. In addition, it will help distinguish between contracts of indemnity, of which marine insurance contracts are an example, and contracts of contingency insurance. An indemnity insurance contract is one which compensates one of the parties, the assured, for his loss. A contingency insurance contract agrees merely to provide a specified benefit to the assured in the event of a stated contingency, whether or not it relates to a loss or not. The third reason why it's important to define what a marine insurance contract is because the Marine Insurance Act of 1906, which applies to and contracts of marine insurance, does apply only to contracts of marine insurance, and the principles of marine insurance which are set out in the Act will apply to marine insurance contracts, but not necessarily to non-marine insurance contracts. Now, that's not to say that marine insurance contracts, the Marine Insurance Act is not important for the purposes of non-marine insurance law, because the courts have held that many provisions of the Marine Insurance Act are declaratory of the law of non-marine insurance as much as marine insurance law. But there are many provisions in the Act which apply only to marine insurance contracts and not to non-marine insurance contracts. It's also important to define what an insurance contract, a marine insurance contract is, because it helps one to actually understand the very notion of insurance and how the legal principles have been developed, and it will give you a greater appreciation of the rationale of the law and an entree into the minds of the judges when they develop the law. So that's going to be the first topic, which is dealt with in Section A, and that's the definition of a marine insurance contract itself. The second topic is related and is important. It's the doctrine of insurable interest. Now, a valid insurance claim under a contract of marine insurance must be supported by an insurable interest. The difficulty with the law of insurable interest is it's actually very difficult to define what an insurable interest is. And I'm not going to explain it today. That's something which will be best left to your consideration of the guide dealing with Section A. But it is important to understand is that insurable interest is concerned with the relationship between the assured, one of the parties to the insurance contract on the one hand, and the subject matter insured, such as a ship or cargo, on the other hand. And so long as that relationship is sufficiently close and of a sufficient degree, then the assured can present a valid claim under a marine insurance contract. Now, the third topic which will be addressed in Section A is the ways of classifying marine insurance contracts. Now, there are actually many ways of classifying different types of marine insurance contracts, but there are four main ways of classification which are referred to in Section A. Two of them relate to all insurance contracts, so that means that they can be classified in accordance with this system one way or the other, but the other two only relate to certain types of contracts. Now, the first two, which are universal means of classification, are voyage policies and time policies. And basically these types of classification distinguish the way in which the period or temporal scope of the policy is defined. Simply, a voyage policy is one which covers a voyage, and a time policy is one which covers a particular specified duration of time. The second means of classification which will be considered is the notion of valued or unvalued policies. And this concerns the question whether or not the parties, the insurer and the assured, have agreed a valuation of the subject matter in the insured. So, for example, a ship may be agreed to be valued at $10 million. Now, that will be an agreement with contractual effect between the parties. Now, all marine insurance contracts will be classified either as voyage policies or time policies, or as valued or unvalued policies. There are two additional types of classification which are considered in Section A. The first is that concerned with floating policies or open covers, and that's really only concerned with insurance contracts which cover multiple subject matters or multiple interests at risk. And the fourth method of classification is that of a composite or joint insurance policy. That's where you have more than one insured. Now, as I say, I'm not going to discuss these topics in any depth. That's something best left to a consideration of the guidebook. The final section, topic which we dealt with in Section A is that of assignment. And this is really concerned with the transfer of a party's, particularly an assured's, rights under the insurance contract to a third party, a non-contracting party. And that position is to be contrasted with the party's rights under the contract itself. So these are the four topics which will be explored within Section A. Hopefully, I expect that they will give you a real insight into the way insurance contracts are defined and work. And I hope by considering Section A in depth, you will become masters of the subject.